down the chain. Just let me put your contact. Yeah. Wait, no, it's the one is.
Yeah.
Huh?
Yeah.
Huh?
Yeah,
Yeah, sure. Right there. I think I already have one with house.
Oh yeah. Michael's.
Alright. Does anyone else want to be added? Alright. The one issue was I think one was
Yeah. Did you?
Jog in.
Yeah, but my like hotspot's like extremely slow. It's not like Wi-Fi.
Alright.
Give me a second.
Yeah, that's not. Yeah, do this.
30 seconds to set up a flow. Is it like new and you already set the new one?
No, it's not you. You just must.
You're not like scrolling at that makes sense. All those autos gonna be like, you know, I actually have these
Everyone did.
Yeah.
Alright. Do you want to close the back?
Yes.
Alright, close the door, please.
Yes, sir.
Alright.
Invention 1 is Husker Pizza, rulemaking samples AI innovation requiring human contributors over burdens firms, Article 24. Grants from the PTO make it hard requirements to invent AI, these samples research will be burdensome to require vendors to adopt it. Every research which is time to provide examiners guidance does not define AI ambiguities, create a sharp investors overturn over options and applications, disavows science, discouraging innovation, and inviting teachers related systems to have patent owners with risk of cost and delay, and overturn the worst will take years to conclude the suits of perception of interpretation over AI and inventorship trends and investment and trade seekers. War 20 federal decisions of machine conduct of invention without inventor. Invention will fall in the public domain, AI works in public domain, reduces incentive. This person the trust and investment of how new works in patent community, and said see trade seekers, patenting AI medical vendors are critical to developing new drugs and vaccine. All outcomes for drug discovery costs, involve the recent process of bringing drugs to market, and our high AI clinical minds robust assist enable problem solving mission every phase, drug discovery from identification to optimization, and big data, identify disease, targeted drugs, and prediction structures, breathe new and simulations run on computers, AI use for the molecules that have never studied or created generate pathways for novel design, and human development fails only AI can handle the complexity of pharmaceuticals for innovation. Roman 19. Human research explores techniques and the perception of molecules discovery since 2017 learning offers opportunities for making discovery quicker. AI can change the cost of R&D, drug discovery, some research of economics, amount of productivity, problem productivity, collecting 20% from more solving ideas. Are extensive by science becomes more complex. Future pandemics are inevitable. Jones 22 covers collaboration for instance, another pandemic situation proceeding to urbanization, climate change probability grows within the next decade. United States will become dangerous. Common form for species to be competition and accelerating the spread of high mutation by virus responsibility. Pandemics cause extinction. Boys, one teachers of high systems critical. Like the entire planet, natural pandemics will mitigate risk of civilization and mitigation of also respond to and building resilience against high fatality. Majority DBs per year as a threat. As we include where AI imply violence and risk increase because BWC validated only take one bowel with accidents and would to be catastrophic. But see vaccines, fertility, diplomacy, otherwise extinction, hold on political stability, drug war, human migration, political cosmicity. I become dominant contractor, drug, we need vaccine, diplomacy, some crisis, will prioritize integrate social determinants, more disability, migration, urbanization, linking biomedical. Social sciences, vaccines, save lives of the most important categories of water, disability, organization, and vaccines collaborate. No all causes the US and key was one more pharma. Everybody kind of have the global total US and kind of dominant share of global pharma market, but XOF figures to increase significantly. Only temperature creates safe air, Dr. Mary 23 recognizing AI as the better for AMP production for incentive and to use air well see the incentive process better serving the US system and invest public ownership for AMP time period for disclosure with a widespread adoption of AI provides the data which AI can make provide public good. Adversarial AI causes extinction avoid 21. Adversarial AI safety can produce and say that giving the risk of the military competence across estimation nuclear war destabilizing deterrence for your pressure to preempt risk as potential risk of AI launch all new center and the event and deadly biovirus or known active catastrophic pressures including satellites. Let the plan the United States vertical should significantly strengthen intellectual property rights and patents for artificial intelligence invented and managed to is trolled. Patent assertion entities are set billions for semiconductor production and development in the United States for cameras AI innovation when Garner's 24. PA's machine availability, semiconductor manufacturers use the patent as leverage against companies specialized in semiconductor contain talents and patent right for use to target Qualcomm. Because TSMC is trying to resources from semiconductor manufacturers and R&D to research specifically, they make reshoring semiconductor supply chains and possible markets. 1, 2. To right research samples and domestic supply chain of semiconductor CIBs behind Lord's worth businesses to delay hiring. Works in developing other provider controls accused the imprint. Impact innovation creates direct costs. Continuing chip dependency ensures US China war. 23. U.S.-China semiconductor relationship remains head competition. Some China rise high concerns regarding national interests and research regarding consumption of silicon shale warrants screening ongoing semiconductor revenue. Governments tied interdependency to compensate negative interactions and anticipation of disruptions that exacerbate disputes, policies, direct towards economic nationalism, both Australia, domestic manufacturing, Taiwan, dependence on heightened security, capitalist friends on U.S.-China conflict, extinction boosts 23. China's the missing rapid nuclear development gene consider nuclear use for returns given invasion of Taiwan difficult for U.S. to win a war over Taiwan. U.S. find self-compelled dynamic bases in China and reverse immediate escalation to nuclear powers will be difficult to keep contained. Countries like rationing battle and extended chip dependency also creates permanent backwards for supply chain attacks on 21. The U.S. military found 1 million bogus forces, including several combat aircraft and national security tech mandated in China and being chips can be also be counter also carries fire and semiconductor the U.S. military government without interim parts secure. And China's share of defense scores 30%, 90% chain manufacturing comes from East Asian disruptions in the market, leading market closer secure. Electric plants fire confidence and chip use and variety applications satellites to arbitrage and software walls are often not hackers take the work up where you try to attack how reactor take the path of least resistance. Military supply chain and has to nuclear here's 1, 2. The UAE introduces second nuclear enterprise delivery vehicles will effect immediately satellites and competition from more digital and companies. Increase attack services for cyber and particularly different risks and connect web sectors that take away and protect prices and touching come with the current software capabilities where the balance of hard uncertainty lead us for reaction and safety consideration. Integration would offer opportunity for demonstration takes time to have space pressure for the plan solves 1 efficiency and better cost on 4. Patent law agreement and efficiency inhibiting cooperation barriers that players exploited. Between AI and version patents that recover the cost of R&D, most efforts do not come to fruition. Cost management results of market 10% of the time that Charles cost and $250 million reward of patents must cover the journey. AI for discovery, greater proximity, clinical success, and analyzing. Routine experiments with higher accuracy, AI manufacturers optimization, analyzing, identify the time predict failures, and optimization of schedule. This reduces downtime and lowers the R&D assisted and design prototyping, generating iterations quickly, reducing the cost of reducing costly prototypes. 2. Social cost using AI avoids power controls. Box 21. AI version enhances the time values for pieces, defensive marketplace strategy, developing quality patents, and developing litigation fees, and increasing social cost of patent rights, increasing hold of AI vendors, increasing social cost of appearance, and rising companies to create quality patents for more cost efficient alternatives, eliminating artists, companies less likely to dispose of patents. The small fees can be reducing low quality patents, eliminating fees, litigating shift the patent ecosystem, favor fees, innovate cost faster, gain freedom, operate at lower cost of amendments, include processing, oversight, computer, efficiency patent portfolios, processing, ocean competition, preventing competition of block by providing local knowledge, innovate patent sold while retaining the rights to limit PAE, encouraging socially beneficial practices over litigation that unlocks effective semiconductor design and resource blocking opportunities on war. AI semiconductors opens up opportunity for industries using models to optimize chip design for quality, allow manufacturers to achieve the efficiency, minimize analyze the delay, predict the quality issues applied in supply chain management. AI can save time create new uncertainty and innovation driven new chips to see this 3. Scale of production sessions, iteration of production based on AI and will make help to work. Scale of production based on AI compatibility with very production based on contribution of AI. We offer contributions like water and high vendors within those instructions of according to introducing quality and accuracy and speed and validation of concepts that one base handy to conform to the different categories for inventions. The inventor produced 5 humans ensure 20 years outside and out of 15 medium 10 high only 5 years of production that uniquely inhibits patterns and prevents tickets. 24. Too many patents that harm innovation form a barrier to achieve proposal, boost cumulative innovation, and eliminate use of production ability for patents to secure injunctions against the juniors. Finally, solvency recognizing stakeholders as patent owners creates clarity in 1 to 24. AI patent protection contributes to the growth and concern of on AI environment without giving categorization of legal persons discouraging innovation where patents. This invention here proposes that there should be recognition of roles of the of an AI and stakeholders and IARD deserving of inventors and inventions. Of course, you have doctrine recognizing the role of an AI stakeholder. Patent rights for inventorship is a sole motivator for successful AI development and creates a market incentive to develop invention machines are also that 24. Transfer must create between about producers and influencers of machine employment. Inventions of creating machines all costing procedure, but producing a cheap is unclear whether these machines develop apples can be patented commercialization. Manchester without production of become toxic transfer from commercialization produces the incentive to invest in machines machines without first place produces commercialization is critical. Yeah, inventions to be patentable. Only patents for quality. Innovation of over 14 patents for roles efficiency purposes specialized in R&D. Improves inventions knowledge and innovative control provides incentives to produce inventions are desirable. The point is to provide incentives to the value of inventions, at least subsidizing invention or rewarding efforts to produce many efforts, but not better inventions government supplies and the absence of IP would not produce incentives for commercialization necessary for the diffusion of technology. Okay. Capitalism is the greatest thing of all time. Growth, sustainable innovation solves the environment. Almost 20. Research is published in the EPI uses air sanitation metals and waste of value for trees and common pollution, water, and active research are found clear positive correlation between performance and GDP. Countries with the highest economic freedom had high CPI, sugar, and prosperity, exporting investments with high it's not the case. Investments with high standards are real 0.1% of the low standards. Capital suits the growth is sustainable. Socialism is bad science. No economics externally applies that industries create regardless of using too much phosphorus body loss, so we use that but keep growing. We've done it. Decoupling is the rise of passengers and forecast features can be passing from members to many countries have grown into couple not just relative, not really product capital is absolutely traded just some global which is already peak. The growth continues to argue that economic facile decoupling to a sufficient magnitude will be evident until already stage development lumps in research use of superior trends and specific research scientifically incoherent. Recycle has a wastewater use another ton of obscure substitution. Okay.
Can you send out Zittelman?
Okay, my timer just popped out, so let me fix that.
You're good. Start of Advantage 2, you've listed efficiency, social costs, and scalar protections. Do you have to win all 3 of those interlinks?
I mean, like, it would be helpful.
Like, do you have to win the efficiency for your scenario?
Okay, so probably. It'd be good if we won all 3 of those.
Okay, let's go through some of these interlinks. Starting with efficiency, it's sort of, I'm confused to why this is not scroll descriptive. What about inventorship is key to this?
Oh, like the parts of the card that literally say AI.
Yeah, okay. Explain the interlink. Why does AI inventorship increase efficiency?
Okay, so AI inventorship allows for the development of AI, and the bottom of the cards is that AI would transform discovery, allows for greater productivity, clinical success, analyzing.
Yeah, I get like the impact. Why is inventorship key to that?
Well, okay, because that's the solvency cards. It's like we would not develop AI to create useful products absent patents.
Okay, why?
Because the argument, I think it's the Rafosin card. It talks about inventing machines. So it's like when you create an AI, it's also like the machine that uses it. Like the machine that creates the AI is also a relevant part of the process. And our evidence says that companies will not create the machines that create the AI that can create the stuff that saves the world if they don't have patents. If they don't think that the output of the AI can be patented.
So if they don't think that they own the outcome of the AI, then they're not going to develop it. That's the interlink?
Yeah. That's
okay. And so how does the plan solve trolls then?
Okay, so multiple arguments. So the FOC evidence talks about social costs. So what social cost means is that when you want to create a new invention, then you have to license a bunch of stuff, and currently, but then AI can create novel ways of thinking or novel ways of making new designs to create the final product. So then we wouldn't have to license, and it wouldn't be people who want to create new things are not vulnerable to trolls. And then the other card, scalar protection. So this argument is trolls are going to try to create a bunch of low-cost patents. The argument for this is that the protections that trolls have, who use majority of AI to create their products, would have less patent protection.
Well,
so
what do you mean low-cost patents? Why is the plan the same?
When I say low-cost patents, I mean trolls can use AI to just easily spam a bunch of patents, but those patents are not going to be well protected within the IP system.
Okay, why can they? Okay, why does the I don't understand why inventorship means that NPEs or other other entities that proliferate patents. Why can't they just,
okay. So the argument of that is that allowing for AI inventorship would create novel and unique ways to create things, so it would not infringe on other patents.
Well, okay, so you beat the infringement part of it, but the proliferation of useless patents. How do you solve
Right, and those.
Protections.
Yeah, okay, so that's a scalar protections argument. So even if there's a bunch of shit that's proliferated, if those are heavily reliant on AI to develop them and not like human contributors, firm investment, etc., then those are like categorized as high.
NPEs say they are human contributors. Like there are like processes in the application process now.
Yeah, okay.
Obviously have changed.
Yeah, okay, so like that's the FOC card, that's the Calvin card. So like again, I think the FOC evidence talks about low quality and high quality patents. The distinguishing thing between this is patents controls grade low quality patents.
Sorry, I replied to the wrong J.
Like you have to add IP.
Yeah. It's gonna be 9 off, advantage 1, advantage 2.
Sorry, I just got it. Give me a sec.
Panel. First off, this calamity can extinction impacts justified genocide and interpersonal callousness, vote negative to reject the plans, naive attempt to permanently contain existential risk, voice 21. After says the bar incredibly high mass suffering when not human extinction do not constitute true risk in this classified genocide, no worse low orders enslavement and COVID would not return existential terms, violent events of the past and present, not existential street threshold events and callousness is bar too high to be used with this model of the suffering on groups on which existential conditions that state this violence will be endurable, so rationally suffering of minorities people, genocide plans to be violence is there on the existential condition that the human acts and commits to that humans can acts indicates that nothing prevents humans from utterly destroying each other. The logic of genocide qualifies as extinction because those who perpetrate them and remake the human condition no system get everyone to issue violence attempts to solve X once and for all to control the origin of genocide will endurable institutions to direct the worst in common aspiring to long-term goals mitigate vulnerabilities of the human. The following arguments are internally turns to their model which prove even if we consider existential risks as important, their model is unsustainable and it's Solomon ban patents compromise. The United States federal government should find patents unconstitutional, constitutional abolition solve, retaining any element of the system by parent fails, and recreates its pathologies due to inevitable political economic pressures. Building coaching practices by impartial economics to administer by incorruptible servanthood, strict church innovation about an system as it exists apart from the research requirements, the system as a whole does not. It's very inefficient and well-designed system where not reform instead of abolishing new acts for the investigate political economy and patents. The system cannot be otherwise optimal. The patent system is not of this world. If political economy pressure make it impossible to reform or make it an evolution system will fail. Abolition by constitutional means is a solution. Patents don't benefit new innovative firms, but do help stagnant old firms lock out competition. Of abolition is better for their internal link. Pollution 13. There is no empirical evidence of increased innovation unless identified with the number of patents in spite of the enormous increase in drug practices you have seen neither acceleration of tech nor R&D and general equilibrium effects on innovation can be negative. Strong patent systems retard innovation with many side effects or initial innovation leading to a new industry is seldom board of a patent only after initial growth mature industry turns the patents increasing and consistent with innovation emphasizing competition and contradict theories that monopolies traditional incentives of government patent system are susceptible to pressures to benefit who won patents but disadvantage feature innovative political domains comes from stagnant industries not new innovative ones and solutions abolition find its instruments less open and rent seeking. Next office is clogged again. Federal cases are down. The culture 23 federal appeals declines accommodation of factors like from pandemic social change to the economic competence to spend money on litigation costs of litigant district court filings with the criminal and civil side went down on a full public court caseload where there are adequate resources. Yes, only 12% get appealed. The low number dropping filings is now true. Nationwide numbers will stabilize. The increase in the number of patent spikes policy and timing sensitive litigation. Mar 16. Litigating by keeping sensitive and time using sense to be millions of patent litigation risky and the resource intensive more. So where more patents are involved, the high risk eliminates the resources to wage multi-year battles. That directly trades off with district court octave naturania. 24 delusional patent case affects the rights of matters. Patent case can be difficult, complicated, time intensive. The other considered effects on mass case migration errors to forms octave effects on formational plans. Defendants form parenting. Substantial case load increases pathologies of patent litigation for form carrying to encompass form carrying. We focus on court congestion, non-litigation parties are downstream. Effects of congestion result from jumping and selling form carrying to represent court congestion docket overload prevents efficient resolution of climate change. Colony 20 was usually similar to democracy. Courts recognize the right to healthy environment. Judiciary places such a role in climate change and litigants ensure implementation of force and evolution of environmental law. Market law warming causes extinction. 19 climate causing extinction do not only defeat cascading feedbacks and multiple thresholds snipping towards ice causes the level of rise melting and increases warming carbon. Releases the methane produce runaway warming and actively lines make extinction likely. Capcan. IP expressions weaponized by corporate leagues and trenches neoliberal capitalism. Right 24 or white 14. IPS and personal society by corporate at least started significantly stronger in favor, at least an interest not visible based on a quiet expression hardly visible because behind technical rulemaking, mystifying doctrine, complex bureaucracies, law and attack and interfere with freedom and curiosity. IPS is an obstacle to the freedom and innovate, explosive pass on knowledge and culture, capitalism causes cascading risks and the culminating extinction. Number 28.3. Human extinction is limited driven by intertwined threats linking capital, environmental destruction, climate pandemic, society, and nuclear war, origin, conflict, actions that are threatening minority, meaning social to survive means nothing, moving beyond capital, escape has been a miracle. Capitalism even has held innovation, create unsustainable growth, ecology captures, militarism to expand its resource bank, markets and protect investment bank, ecological thresholds, key issues from the using space spending, increase benefits of military companies, produce nuclear, biochemical, and cyber war, all are systemic, intensifies institutional dangers of each other, climate exchanges, drive war and the war cause of climate, and can vote in favor of the united revolution against capitalism. Peterson 23. Comments are coming through due to climate disasters, war, strikes, instability, countries, information, and entire generations despite desperate to find a way out. The recent polls reveal Gen Z and millennials expressing a favorable view of communist shifting worldviews, middle deceiving with its after defeat of BLM, despairs being transformed into class region, desire to strength of these forces lies in the numbers here, and their willingness to spontaneity and revolution, not enough. A lack of organization can be fatal and confront the capitals, even in organization to find itself always later on the basis, unable to play a role of version of capitals to harness energy, and the revolution must come as a bold critics of capital, offering organization to start and understanding what communism social is not a redistribution within capitalist revolution, rupture, property relation to the economy, public and democratic communism, super abundance. We must have urgency. Self-size protection of property requires protecting all forms. House 88. Term protection of intellectual property means the country provides means under its law for protection, state secure, north in all forms of intellectual property. Violation of the Act does not strengthen the entire area of patent law. Prefer allowing minute topic to each state topic here exposed to topic to tiny apps that don't even change the square ending net grounds. We generous. The United States federal government should significantly strengthen intellectual property rights for artificial intelligence innovations by a sweet generous scheme for protecting intellectual property, stretching existing IPR to cover new areas causes uncertainty and an explosion of litigation. Sweet generous souls. Darny, and then Freely 19. Congress should agree protection is required, but bill to agree what type of copyright treatment patent treatment decision requiring courts to determine the protection of appropriate kits rather than preventing lasting internally proposed solutions. Unique character remains a sweet generous solution. Of course, becoming experienced with IP, increasing control as they attempt to manipulate existing framework, unsuited to field protection with this constraint, impossible collision litigation, uncertainty in the bill, demonstrate mistake with definition within copyright law, which is principles produced. This is an inadequate result of the principle of devising separate category of protection. The uncertainty can be eliminated. If the next off is ASPEC lack of brand specification is voted for limited value. Topic is doomed for day. Has an agent accountable to make all of them non-competitive, incentivizing vagueness, which hurts as a race to the bottom. Next off is a necessity accountable. The United States federal government should find that to torches public necessity compels strengthening and protection for artificial intelligence inventions for narrowing into intellectual property rights protection to exclude providing exclusivity for artificial intelligence invention, applying the necessity doctrine to IP solves and revitalizes pandemic response. Hello 21. Good to respond to public health, copyright, inflexible right yield, troubling rules of crisis, supporting digitally overrunning interest, yield, liability, education, only literature, review of that loan sense, use of text, not occur due to overindustry, inability, meet needs worsening, ETCs, the IP needs a flexible solution, except taking conduct for liability, solution balance, and established rights with access protection without permission toward necessity, incorporates the doctrine as for other necessity, encompasses act, and for imminent disaster provides defense that shields any liability results in privilege, IP law involves constantly judges deciding matters, allows litigants to implement his doctrines from other law doctrines later becoming according to statutes there are no doctrinal impediments, IP's connection, address deficits. Extinction Cam 21. Evidence for human life that the sudden spread of the disease remains undiscovered. Simulation reveal a risk of disease effect. Although these lead to extinction emergence, frequently extinction and global risk of black death, smallpox, and will affect a large population risk in pursuit of mobility. Extinction for despite every person of studies is not conduct quantitative assessment. We can survey our disease characteristics results reveal extinction. Advantage 1. One vaccine diplomacy fails common to 14. Research investigate how a vaccination might generate fees based on empirical evidence. Conclusion activities do not agree, even if return diplomacy is not successful. Activity has no impact on disaster effects and more significant impact. Examples are mutual distrust, historical, groups such as desire for conflict due to adventures. Conclusions have been corroborated through case study. Fundamental test activities are not high priority. Domestic policies outweigh. Mark two. The AI is better in command and control. Cox 21. AI can snoop decision making. EW avoiding escalation. AI prevent false positives. AI may improve speed and quality or identify processing. Eliminate biases from leadership, which will be crucial to allow de-escalation. AI can discriminate false information, which is critical. Miscalc, advantage 2. 1. No China war, 22. Restraints for prosperity, 70 years to prevent conflict, extensions will not lead to no war. Diplomacy for Solomon's perspective, leaders communicate, now we're going to have a stake. Every government would prevent conflict through mediation, no resistant globalization makes war unavoidable. Prostitution cannot ignore. Voters' public is very the price to perform watchdog function, final fail safe, return which survival, strike balance of terror, holds. China and the US will seek accommodation. 2. No Taiwan invasion, Madeira, 21. Myths are to study journalists misreading calculus and current situation. China view Taiwanese political, non-military business preference has been to disturb rather than compel unification. New horizons, textual love, cheese, anxious and preparing invasion. He never settled deadline invading. Remains extraordinarily risky in the next years at a crucial time for Xi's domestic entry. At that control, even if the invasion succeeds in China, have to occupy getting the economic calculus remains complex, far from a no-brainer. 3. No supply chain impacts longer. 22. Negligible role of cyber in Ukraine should come as no surprise. Simulation, statistical analysis, and studies found little of cyber arms. They cause escalation. Hundreds of incidents have occurred. None have triggered escalation. Market escalation.
Wait, sorry, which code was that?
The longer in 22.
Okay. You good?
Yeah.
Okay. Status.
Condo.
Okay, besides protection pick, did you skip anything else?
Yeah. I skipped the disease defense.
Oh, but any off case?
No.
Okay, got it. And then clog decide says status quo solves warming, and the cap case says status quo causes extinction by warming. Can you repeat these two?
Yeah. So it's a proof of serial policy failure within
Serial
your
policy.
model,
You
i.e.
said
that.
warming causes extinction, and then
So
warming
the
doesn't
so,
cause
so the 1AC said capitalism solves climate change. It proves that even under your model, courts get clogged and climate change still causes extinction.
So the 1AC said capitalism. Okay, so you're conceding the.
It's an even if claim to prove
How's it-
that
you've made two
under
distinctions
your
of the status
system
quo
of
there.
capitalism, there's serial policy.
Got it. Okay, and then this new counterplan necessity. Okay, so what word in the plan does it not include?
Well, we don't think it's a right.
Intellectual property rights.
Yeah, true. It excludes intellectual property rights. In
The
fact,
counterplan text.
yeah, if you it explicitly narrows our current jurisprudence to
Got it,
exclude the
okay.
plan as a right.
That makes sense. And then how does it? And can you explain the mechanism of this?
Yeah, so the necessity doctrine is a way of implementing tort liability in patents. We think we've read the Hellid card says that it would mean that in times of great public necessity, then the right or the patent or whatever would not be granted if the
Or
courts decide that.
you can infringe on a patent
Yeah.
and you won't have
Like it's the
liability.
necessity defense is when someone can determine
Okay,
that
so
their
so
invention
post plan,
requires
if someone
public
wants to get a patent for an AI invention, what happens in the world?
So
if they get it through the normal application process, unless public necessity determines that they should.
So if
basically.
public necessity does not determine it, then the counterplan is the plan.
Not exactly. I mean,
Why?
we don't think it's a right to a patent at all.
Is
So
there,
it's not
is
guaranteed.
there any
They have to
world,
prove
okay,
there
pause,
is some
pause,
public
Is there
necessity.
any world
yeah.
in which the counterplan fiats the plan?
No.
Something very similar to the plan, but no, it would not fiat the plan.
Could it result in the plan?
No, again,
If-
it's
if-
not a right. No.
It's not right. The sweet generous counterplan is okay. That benefits everything, by the way.
Sui generis is clog. Ban patents is like the turn. And then everything else is a turn.
Okay. Now, how does it solve disease?
What? The necessity.
Wait,
counterplan?
actually, yeah, can you
So-
explain how it solves
Yeah.
it?
Yeah, so in times of pandemic, patents on medical devices doctors would have the ability to infringe on those if a patient needs it.
Yeah, Hellid
Okay,
cards
so
is
then, so this is like the waivers good.
It's like, yeah, it spills over to things like, not particularly waivers because that would ban all vaccines and things, but certain technologies that necessitate infringement,
And then when the
they would
counterplan
be
text
banned.
says tort.
Tortious, yeah.
What is that?
Tortious liability is a way of civil liability and adjudicating
So is
infringement.
it like a normal person pursuing them?
What?
It's like a normal person that like invokes the torts.
Like a court?
A court invokes it.
Well, yeah, it's like
And
a
what is
kind
the
of
agent
liability.
of this counterpart?
I mean,
The
it's
same as the app.
USFG.
Got it.
Judicial branch, probably.
Oh, all in the case, yeah. Yes.
Yeah.
Well, which
Well,
kid?
yeah.
Yeah.
Alright, stop. 8:18.
I can see the doc in my email, but it's like not let me down. Okay, I'm good now.
It's the healthcare advantage, controls advantage, A spec, T subsets, band patents counterplan, the cap K, the calamity K, the necessity counterplan, sui generis, and the core clock. Anybody need it again?
I did it again, be safe.
Healthcare controls, A spec, subsets, band patents, the cap K, the calamity K, the necessity counterplan, sui generis, and then core clock.
Go.
Jeremy, you good?
Yep.
Okay, y'all good?
Yep.
What is wrong? Vaccine diplomacy, soft 16 shit facilitates global cooperation on health risks prevents political instability, resource scarcity, and nuclear war that's hoax. What is 2 is wrong? Only recognizing and leadership can ensure safe adoption which prevents unsafe and from causing miscalc, attacks, and infrastructure collapse, and future pandemics and attacks causes future from civilizational collapse and globalization. That's boy dropped and Trump solvency on advantage too. What is wrong doesn't assume semiconductor resilient reliance, which here sits as a unique weak point of the U.S. that China wants to captivate. 2 is wrong, cross supply, answers from above. 3, yes, supply chain attacks or evidence doesn't assume that military hardware is already corrupt, which causes extinction, early warning, shutdowns, creates use of elusive pressures, and preemptive strikes that goes nuclear. That's here on A-spec. 1, we may specify ideas of the apply text in 2, in chart breaches have to be topical, cross-X, and fun normal means strikes, 2, functional limit strike, and agent counterplans are bad, unpredictable, stealthy, app, and hiding. Actually, skip that on T subsets. 1, we affect all patents because they can all use AI now. 2, we meet context in a vacuum. That's the most objective on band patents. 1, condo is a voter. It's used into AC and sandbags block that the dispo solves means they can kick in firm theory. 2, perm do both. 3, perms in counterplan. 3, only inventorship fosters cross licensing open innovation. That's fuck. Open innovation safeguards humanity from existential emerging tech clock. And 18, all problems are complex and new weapons of engineering and nanotech genetics and robotics both. That's a humankind collaboration result in innovations improve capacity to manage tech. And what is openness is necessary for evolution to manage tech. Under low openness leads to expensive discovery. As we see with gridlock openness, optimal for management to keep pace with threats on saving. Grace blood patents are key. A solvency patents sure the creation of inventing machines. That's key to app. That's Rosa Fuso. B, commercialization that assures adoption, which is key to successful innovation. That's Spielberg. C, pharma. It's key to recoup failed innovation. That's Hellman. And the counterplay can optimize synthetic biology, which assures extinction. And L19. So this in biology, technology beneficial for gene therapy, full sex, service management benefits, and biologists, global needs of biofuels, and food security, medicine benefits, gene eradication of disease, pest harvesting, pathogens, and target tissues, chemicals, targeted gene targeted therapies, to clean up contaminated sites for biology mediation, suitable regulatory framework, discover upfront investments, and no link to patents. Bad frame every argument through AI inventorship. It streamlines innovation with decreases deadly loss for 1, pharma. Its accuracy skyrockets. That's Hellman. 2, semiconductors, equipment, and designs are optimized. That's Hellman. It also decreases trolls and thickets. 1, ordinary scale runs for 24. Invention being obviously obvious to an average person in the field with access to trolls. The prior art, more likely invention is obvious. Accessible for applications as companies to the illegal. Standard will adapt examiners assume potency. So has access to the AI will raise the bar for obviousness. 2, vagueness trolls rely on uncertainty. Print 17. Patent trolls serve no purpose. Trial trolls rely on broad interpretations of vague generalized. So uncertainty. 3, scaling projections. It decreases durations for trolls to use AI. That's Hellman. Also, patent profits are key for pharma innovation with solve disease. That's Hellman on cap. 1, framework only evaluate plant desire. I believe that tells way in the case having links to the plant beyond implications and competition should only be derived from types and functions preferred unpredictable critiques that may clash in fairness that turns the all because we can't research it. 2, perm to both either all overcomes or the links is insufficient. 3, extinction outweighs the most terminal form of violence and agency. 4, perf con disproves the framework arguments and proves that capitalist radicals is still true and inevitable. And huge double turn that cannot say the status quo solves warming on flaws and the status quo can't solve warming here. We get new answers when they remedy. And 3, the alt fails. A, it's rejected. It's subject to crackdowns and opposition. B, case turns the alt collapses the IP system and AI innovation with constant extinction. C, no spillover. 1 round fails to ignite movement. 6 rounds happen simultaneously. We have lives outside debates and debaters lie about art that they don't believe in. 4, international object and private after fiat is a voter allows for the world peace counterplan which is unpredictable and unanswerable. Kills clash fairness. Slowly picks our voter. Unpredictable moves the case and debates. Clash and the all harms the environment. Reagan 19. Such a plan is proposed to sound like resources and routine energy transfer. Highly subsidized industrial production where more energy intensive like 10 times higher related problem for fixation of socialist planners and heavy industry at the expense of environment. Central value use. Cost excessive use of resources for regular economies use about 1/3 of those. Energy and steel per unit. Socialist planners lack knowledge and rationality. 2, coordinate activity is responsible to hold governments accountable. Property rights for protection against harms against resources owners instead of a concern on the climate change. 1. Cross-apply framework layout perms and extinction outweighs. 2. No link. A. The plan doesn't uphold the IP system or affirm its legitimacy. It's a demand to change the system, and extinction reps are inevitable. Perfcon proves that, but it's good. Generates empathy. 3. The alt fails is subject to crackdowns and oppositions, and cross-apply all the theory arguments from above on necessity. 1. Perm do both. 2. Perm did the counterplans. Counterplans must compete off text and function, key to AFCON and germaneness. 3. The counterplan can't solve only a signal of clear inventorship is key to prevent trade secrets, which hinders innovation. That's word. USPTO will also say no to the current doctrine that's adorned evidence, but tort law fails one procedure. Bird 12. Hope is not sufficient to damage damages for tort. Plaintiff may allege TI with present customers, but no cause exists for the community damage. An asset can be supported by expert testimony. There is no basis for recovery of TI for execution and event must be costly and testimony will increase. Litigation cost 2. Innovation. Gibson and Doug 20. The California Court of Review towards the court concluded that the plaintiff must allege the defendant engaged in a wrongful act, live claims of interference without any required independent wrongfulness with show competition, expose routine competition to litigation. 3. Public enforcement towards no habit, so only injured parties can bring cases, but public enforcement is key McAfee at 08. Public enforcement increases social welfare, and private supplements and firms are more likely to use law strategically to determine consumers may have the government only sue if legal action is taken. The government only sue if the cost of firms are high, but in this case, firms never sued, so pure private is never optimal. And perm to the plan, the counterplan over another issue text inserted, and perm to the counterplan, then the plan should refer to the future around 08. Should look to the future considering possible future events, and no net benefit. 1. Reject logicless impacts, no terminal. 2. No spillover. 1. Instances in key. 3. The plan solves disease, drop solvency on case. 4. Counterplans that result in the plan are voting issue, steals the app, and kills clash. Sui generis. 1. Perm to both shield the link to clock because cases will go to specialized courts. 2. Perm to the counterplan. 3. Can't solve the app. 1. Innovation. Also 24. Sui generis is for innovation. Company pursue one option over another depending on the type of right vaccine. This should be produced in a most efficient manner. IP rights may neutral to certainty long low way. Sui generis problematic because you have a predicate. We don't know what the tests are. We don't know how they're going to work. It doesn't fit. It's too far. It's far too functional. It goes somewhere else for legal protection, and that ensures trade secrets which hinders innovation. That's above 3. Clog. Warwell 23. Adoption of database directed led to litigation across Europe. Whether a database of qualified for protection, ECJ decisions traded. Litigation on certificate British directness is inappropriate and appeal. 4. Guidance. The counterplan doesn't change PTO doctrine, which is key to solve that, and the plan solves the net benefit. IPO 20. Actually, no. Skip that. Unclog. Patent applications in courts, patent application clogs that records high to McDermott 24. USPTO 25-month pendency for patent backlog, slowdowns in targets were reduced. Backlog is predicted to increase by 820,200 by 26, and litigation is inevitable. PTO uncertainty surrounding your AI inventorship invites litigation. That's Yahoo specifically. Trolls target semiconductor patent holders. That's Wingarded and Marcus, but the plan solves trolls. That's case. It strengthens participating entities' defense instead disincentivizing litigation. That's the FOC evidence externally. The lack of clarity over inventorship opens the floodgates to litigation. Mahama 21. System breeds cancellations as human inventor without satisfying standards and company B relief. Invalidate patent company A would be unable to prove inventors conceived of any approved patents unable to survive review, thus providing little protection. There is difficulty drawing the line open. Floodgates of those seeking intent to serve patent invalid by erroneous inventor would take resources to uncover, and distortion is an existential threat to the patent regime. Doris 20. And a patent law here human no longer center of innovation in the public is doctrine founded by the idea only humans can be inventions dissolves the law foundation unless we fill the vacuum systems. No time is inevitable, and we need to update to keep the system operative. And inventorship allows for AI adoption. Mayor 23. Recognizing AI as an inventor, patent protection provides an incentive to use AI robustly in the inventing process, better serve the US patent system, and manifest public ownership with widespread adoption. AI provides data which AI can be innovated that solves litigation. Run at 22. AI solutions play a role across patent ecosystems, improving efficiency and quality, support faster examinations between offices and avoiding costly litigation challenges for bad patents, and AI bad patent offices include classification and efficiency and multiplier for operational sustainability. 20 seconds, anything?
Sweet generous compound voting.
Sweet generous counterplans are a voting issue. It's unpredictable, and it steals the affirmative.
Extinction K voting issue.
Extinction critiques are a voting issue. Actually, no, PerfCon is a voting issue because it makes the 2AC have to contradict itself, kills clash, kills fairness. Extremely unfair, actually. I'm moving for cross.
Gift package or something.
Yep. We'll wait for the gift package. Alright, I got it.
Because you're extending that counterplan.
Huh? I don't know.
Alright, gift cross.
Here's that.
Reasons to reject.
PerfCon. Sweet generous counterplans.
Yep. Extinction case.
Extinction case. Conditionality. International, private actor fiat, domestic, non-domestic actor fiat.
Okay.
Utopian fiat. Floating pigs.
Yep.
Oh.
We already got that one. Okay. All right. I want to start on the torts counterplan. This innovation deficit you read is about, let me read a shrunken part. It says, with an at-will contract by a third party, how is a patent
Sorry,
an
what?
at-will contract?
What was the first part?
How is, so your Gibson and Dunn 20 evidence, it's about at-will contracts. How is that all patent law?
Well, it's about the perception of the tort.
But where do you think this card makes a claim about the perception of the tort? It's just citing a case from California.
Yeah, talking about contracts about torts.
Okay, so how is that the counter?
Correct me if I'm wrong, the counterplan is using tort law.
But it's not contracts. Explain to me, okay, the Burr evidence, what do you think, why are going after torts liabilities expensive and prohibitive to patent holders?
I think the card isolates specific ones, like how prosecuting and hiring defense attorneys for tort law specifically is an extremely costly process.
So what about tort law is different than patent law in terms of the litigation process?
Because I think it requires extra expert testimonies, because for patent law, a lot of the judges that are kind of litigating and deciding these cases are already experts in the fields. That's why people bring patent cases as per your litigation evidence. to
Wait.
specific
So like district
courts.
court judges are experts in AI
Um,
inventorship?
No, not AI inventorship broadly, but it's just that in the areas of the patents, not AI inventorship. So like, let's say I'm filing for a pharmaceutical patent. I would bring my patent case to a specific judge in the district courts, which you've read link evidence on the clock this at, that is more knowledgeable about pharmaceutical
Wait.
developments.
So you're saying that patent lawyers just like choose the court they go to?
That's
Yeah. You said that.
yeah, that's your link evidence on why we flood district courts specifically. The card that Forsland cut that you cite, I think it's a third card.
Yeah. Okay.
Litigation to stat is
The
not
Rossen,
bad on this question.
the Rossenfoss evidence on the sui generis counterplan.
Yeah.
Could you explain to me the warrant of why sui generis delays innovation? This just seems to be a claim without a warrant.
Quote, sui generis right could distort the innovation ecosystem
Yeah,
as
so-
companies pursue one option over another depending on the type of right. So it's kind of
Okay, so
Company-
if so if the patent right does not exist, then why won't they just go for the sui generis right?
I guess it's because companies will try to lie about it and be like, I could go to this one, or I could go to sui generis, and then that wastes resources.
We're gonna take
10 minutes.
5:45. Sending it out. The orders the necessity counterplan, advantage 1, advantage 2. Yeah, I just got some. Are you all good? Wait, sorry. It's opening.
Wait, real quick, did y'all ever send out those tab cards?
Yeah.
They sound it on
After the one.
Yeah.
Okay.
Alright, everyone good?
The counterplan solves the case and applies the tort of necessity to the plan, granting liability for infringement when necessary. The counterplan finds A mentorship to be a necessity, immediately granting protections equivalent to the plan that's held. It's a fail-safe that kicks in during crisis. One steps is held. 21 IP includes the limited enforceability COVID, providing the counterplan for actions necessity coexist without a max embedded, and it operates like a safety valve available during crisis. More salient light of difficulty to balance solution effects. Tech kits underused, licensing too slow, and can't catch up with crisis. Held 21 underuse of tech is attributed to IP. Is attributed to inadequacy, speed, and flexibility protected tech, dependent, complex, and time-consuming negotiation with highly user laws. Presumably of the time, resource, and expertise negotiations, non-making negotiations, and allows for flexibility. Purview both fails. The counterplan bans the plan dropped into 2AC courts narrow IPR jurisprudence to exclude creating an exclusive right for AI mentorship. The plan must guarantee a right, so it's abolished. No new answers, block choices are made by 2AC mistakes. If you do the work for them and exclude the second part of the counterplan, doing both is still impossible. 1. Exclusivity of the plan. Fiat said providing a carve-out in the same area causes overlapping requirements, and DEX credibility. The firm can't simultaneously provide exclusivity and necessary infringement. DEX precedent. At best, the firm gives unlimited protection via IPR, and a partial protection means investors won't infringe. That's Heddle. 2 is overriding interest. Should warning new liability requirements and rights causes overturns, which prevents second option. That's Heddle. And certain reference. 3 is displacement, including IPR alongside torts, degrades its attractiveness and causes courts to refuse to recognize it. 8. Alternatives to torts throughout the court's desirability are realistic, even if all torts that address the harm to the fraud were allowed another approach to reform. I'm not arguing choices of work. First comment another point of the remedy displacing torts refuse to recognize torts on other possession theories that address similar ills. Future cases will be remanded because the courts the confirm makes the alternative remedy of rights available. Gregory, the court rejected the tort claim. Thomas concluded that even if 301 did authorize a federal claim for torts interference, it would be premature to decide that the granted market not showed other remedies are available as policy. Other remedies still available claims would fail on remand. 4 is mixed liability. The combination of distinct liability regimes breeds convoluted incentives, crushing investment goal. 15 tort gives people incentive to evade hidden things which will not occur to negative externality, multiplying the damage probability of occurrence bullying, and puts the cost of $80, benefit of $100. Imagine the device costs $110, cost of precaution outweighs the tort, provides externality, all exceptions to page, behave efficiently. Now, per to the counterplan, it severs the 2AC drop the counterplan, narrows jurisprudence to bend rights over the plan's error. Competition is absolute, and it can't take out solvency, because the 2AC conceded that part of the counterplan still solved, despite the plank that bans a right. No take backs or new answers. Again, block decision rely on 2AC blunders. IPRs are exclusive. Quinn, 2 bytes fair nation IPR are exclusive. It means that IPR provides the holder the opportunity to grant the rights from engaged in courts, held the exclusive, unlimited by all limits. By demand, rights are permanent, non-infringible. EC, 24 distinguishing grants of privilege and rights of critical analysis not confounded. Privileges, class of rights, and devotions defensively lesser. Permanent existence of rights is subject to condition of exercise right. It's used to extend a right that is sort of permanently precluding invading. Necessity grants a contingent privilege on a right held. 21 the privilege of necessity is conditioned on proportionality to actions taken from the interest must not do to disproportion to the harm caused by the tort features. Torts are legally distinct from IPR. 11. 5. The modern IPR is distinguished from torts unlike property which focuses on the rights to exclude torts and compensate the parties. Torts focus on the defendant's conduct rather than incentives built around unjust infringement of positive externalities or spillovers. The counterplans market-based exclusion, not rights. Baca. 6. The rights-based exclusion entails leveraging traditional IP protection to make money. Market-based non-exclusion entails selling goods under traditional conception of property, not exercising exclusive IPR. Prefer 1. Limits. If it's not a counterplan, it's an app. Guarantee grants infinite non-rights apps, which discloses this topic because you can have an infringible
patents that try to die when the applicant already expand this, affirm the status quo and be topical. 2 is ground. Their interpret opens the door to non-durable infringible apps, which is leading to granted ground from patents bad or exclusivity bad, which seem or clog, which steamrolls the neg. Now they say certainty and signaling. It's 0. It's a clear signal towards liability. Is regularly incorporated into IP, so it's not other liability regimes are, so it's not outlandish to break from existing practice. That's highlighted. It's also non-unique. IP is constantly evolving, including constant doctrinal changes. It's for reference, no impact there. It's their evidence is about certainty and outcome, not the process. The protections resulting are essentially very similar. The rights are also worse. They're uncertain and time-consuming and subject to political capture. Turns case held 21. Underuse of text distributable data and adequacy, complete speed, flexibility, contemporary machines, make text dependent on highly flexible, time-consuming negotiations, highly uncertain outcomes, laws. Presumed parties of time and expertise negotiation, economic allowances, mechanisms are politically frauded, rights depend on very goodwill, and present enforceability problems. Turns case, attempting to shoehorn the app into an inflexible regime. 0 solvency. 22. Each IP regime developed resolve differently problems and apply rights in corresponding ways. Each regime designed to specific set of traders and not matter not one creators in the wrong forms. Disturbed IP laws carefully calibrated balance when creators evade requirements of this type of competition. And tech events as fiat solves, investors don't know about it, so the counterplan is perceived as equivalent protection, and the tort standards are clear and easily navigable by business. They mirror the UCC, the gold standard for commercial conduct law. 97. The intermediacy is not referred to the tort bar, despite the rules of the benefits. The use of generalized ethical standards commercial settings is not unique. Even UCC includes overarching fairness, prevents the norms of the number relationship. Less clear than TI allows for more unpredictable churn on TI than fair dealing. The UCC argues that TI is exposed to vague standards overstated decision making. Not ever proves that the function of rules of fair to shilling is exaggerated. They say signaling their primary function of torts is expressive. The signal is powerful and clear. 18. Tort is expressive institution that justice and defendant your wrong liability and judgment of the benefits open up to the plan plans. Fail to see that a tort adjudicates that clearly and loudly. Judgment on the ability is the business towards expressive institution. Primarily, they say the USPTO says no, it's wrong. It says it's the same result. Essentially, it would recommend the same provision as the admin protections, just without a right. There's no evidence that rights are key to this. Saying yes, it would establish AI mentorship and ban duplicative patents. Now, procedure is wrong. Their fiat solve the expensive problems where there's no impact. Their card's also about antitrust suits, not patent suits. No link to innovation. It can't be applied to protect competitors or competition because the counterplan does not apply to antitrust law. Now, they say public enforcement. Again, it's about antitrust suits, but so no link, but full piggyback on private jurisdiction. District 19. The federal enforcement can piggyback on private actions because the common late periods and deficient about not duplicating further resources piggyback can pull leverage resources. There's multiple methods through direct action or hiring private firms to sue competent. 17. Public enforcement can pick up private cases. Public piggyback on private if the enforcement included deterrence maintain the increased efforts and agency shift resources leverage the hiring private enforcement. Public enforcement adopt taxes not private enforcement. Now they say perm other issues. It's illegitimate because it adds function. 1 is ground internal net benefits get erased. Those are the only way to produce offense on this topic. Perm snowball to full insurance yes, deleting germane offense. 2 is perm gaming, text hit shovel to add unpredictable functions. 2 is shave words off advantage counterplans if you add advanced. 2 is can also distort plan functions by inserting extraneous words in the text. 3 is real world decision makers evaluate policy based on function, not text. Supportable education by comparing function first. Their makes ban the plan not competitive, unpredictable. 4 arbitrariness. The rest says USFG should denoting debates over functions diverging from resolutional ground. Dex the neg's ability to engage, justifying arbitrarily limiting out every other neg position. The resolution calls for debates over actions. Erickson. The 3 topic contains the elements of nation doing a United States endeavor showed Saxon policy to the governmental means debate about whether something ought to occur. 5 is textual topicality. Their just by removing function the rest if the app retains partial resolutional wording then unleashes a slew of discourse-based advantages or textually topical plans like state should shrink it, which eliminates net ground. It also fails because it looks like to do both. Interpret the function of perm as defined by the app, which most closely defines that there are only red definitions about IPR and protection is the 1C solvency advocates, which makes it look like the plan independently is vague, which is not specifying what other issue the counterplan is over, which is voted for fairness. Towards a unique independent movement to create a critical mass. Graham. 16 attorneys provide life go to transformation law. Let us not appreciate each action. Then will appreciate towards not have lucrative the attribute the shift to perceived advantage in pure toward over warranty towards not covered because some of the problems referred to warranty advantages or imported to show and swift adoption for tourism. The circumstance of the preface are partially owe the warranty as compromised part of a sort of crucial moment. The firm lacks such great appropriation that guts general recognition of the tort cornet. 21 a cause must provide to treat a concrete standard for proposal dismissal as a death knell for a novel action of free for general recognition of causes just viability hurdles. The first significant momentum leads to a new tort that may not be overcome by hurdles to achieve recognition. Perm 1 bans the plan exclusive protection. Perm 2 bans the counterplan because the necessity isn't exclusivity. That wasn't part of the counterplan. Perm 3 looks like you both. Perm 4 does not solve because it's not applied to the patent doctrine. Perm 2 the counterplan then the plan is illegit. 1 is time free purpose. Along specification avoid sequence and net ground. They'll do the plan after the politics is passed or after Congress has allocated more funds to USPTO. 2 is intrinsic adds the word then and functionally specifies sequence.
Well, I think we're going to take.
6:30.
Alright, I'm good.
So walk me through like gist of the counterplan.
Yeah.
30 seconds.
So the counterplan would establish a new protection on IPR for AI inventorship if the plaintiffs can prove that there is a necessity based off the public situation, whether that be like
Does it
user
beyond
sponsor.
the plan happens?
No.
Okay, so it's just like who recommends it?
I mean, it's the courts who are. There's no recommending. Like the courts are doing and implementing a very similar policy to the plan, but an infringible patent right or infringible patent. Like it's not like it's not. It can
Someone infringes on their
absolutely.
patent. Like they can't sue.
They can sue unless there's a public necessity that makes them that infringement.
What is the standard that the court uses to determine?
Yeah, so the necessity doctrine has been used in other like applications, and the purpose is like if there's some like public crises that's happening, we shouldn't like hold like infringement standards. Like, we
Okay,
shouldn't
so
hold like infringement
If
standards.
there's like one pharma company that just wants to make like hella money right now, is that a public necessity if someone infringes on their patents?
If they want to know, that's not a public like crisis.
Okay, so
The
like
Helen
pharma
card,
companies
the Helen
who
card's
want-
about like pandemics.
Okay, so but like pharma companies who want to kind of just make money based off kind of new creations, if someone infringes on those patents, the courts will be like, that's not a public necessity. We're not going to grant you.
Yeah, I mean, if they're like if a pharma company doesn't, if there's not a
Okay,
necessity
sure.
to infringe on the patent, then sure.
So your card's about pandemics, like you just said.
Mhm.
What about semiconductor production? If people are like, oh, I created this new semiconductor design, someone infringes on it, will the
I
courts?
mean,
rule
maybe
that's a
like
public
or
necessity?
like okay, maybe back to the healthcare. I see what you're doing here, but like back to the healthcare thing. Like,
Uh,
obviously,
I mean,
like
you already
if,
said what you
if
did,
there is a
Russell.
pandemic, if there is a pandemic
All right,
that
Russell, you already
necessitates.
said what you did though. Like,
I mean,
you
I'm
can't really take
explaining
that back.
further what that means. Like, there, if
Okay.
it's infringible, right? If
Okay.
there is a public necessity.
Wait,
Same
you
with
read
software.
Erickson?
Same with
Read Erickson.
All right, as you were.
yeah. Same with software. If it is infringible, necessitates there's some kind of public crisis that we need to be able to have some like
Sure.
collectivized production mechanism.
The
then
terms case argument seems to be super vague. Could you explain it a bit?
Yeah,
How's-
I mean, like you try to integrate like IP into our Helen card says like IP is now like a very inflexible regime, right? Like rights do not allow for any like accommodations for any
There's
kind
like
of
licensing
crises.
agreements that could be made and stuff like that.
Okay,
which-
not an argument in the 2AC. We have a block for that. If you read that, I would have read it too. So no new arguments. But
Do you not
licensing
think
does
the
not
2AC
solve.
made like some new arguments that justify
No. But
Okay.
licensing does not solve because
Okay.
there's still public action problems when we infringe on those patents. Like whether it be like companies don't want to license out their patents because they want to hoard their innovations in times of crisis.
So is the terms case argument just like patents bad? Because like people.
Not exactly. I mean,
That's not-
there's still some exclusivity unless there's a public necessity. For
Okay, but like, can you explain the terms case argument in a way that's other than patents bad?
I mean,
like
it's
you
that the current IP regime is so inflexible.
So
that
it's just
trying to-
patents bad.
No, I mean it's IP. Yeah, sure. It's like
Okay.
current patents bad, sure, I guess.
One order was sent. We'll leave an order in a second. Yeah, so it's going to be the torts or the necessity counterplan, T subs, the abolish counterplan, the cat K, court quad DA, sui generis, calamity.
Calamity?
Sorry, do something. I need to. Wait, what were the last two?
Sui generis and then calamity.
Yeah.
Three is reciprocity. Even if they win the act, doesn't have to be immediate. It has to be the same time the counterplan does. Key to fairness: the idea that fiat is immediate for the counterplan, but not the plan, is grammatically incoherent. Four is vagueness. Impossible to tell when the counterplan has finished. And the pandemics outweigh, they spread globally, mutating and combining affect everyone, cause extinction. That's can, and it solves the aft better because you cannot implement the AI inventions. Absent the necessity doctrine turns the case, not a laundry list. It's a pandemic's impact and expanding tortious interference, stops natural degradation, unenforceable public trust, extinction, canner, to ideas of the natural swimming for impairments and natural resources which was available to just their society time of PCD. Courts to recognize and empower trustees. These protect future development, public trust involved. Water to protect water, air, and land. The doctrine of facilitate survival of society to be available should be improved. TPTD focuses on obligations. State has the affirmative obligation to ensure rights are protected. TI is a standalone claim. Parents prior to give the state standing to prosecute. TI does not require proof of due since their trespass or any other sort of practical trust includes fisheries, kind of water, area, wildlife, and the resources. But trust is not self-executing. States should sue for TI deter misconduct and spur restorative actions. Historically, courts we hold to claims this invokes a formalism and suited involving jurisprudence could be vastly improved by recognizing tortious interference. And yes, spillover doctrinal tweaks and purely get incorporated into the broader IP regime that's held, and incorporating necessities for systemic changes. IP law held 21 protection terms of the law provides mechanism for addressing tension in the form of necessity. Republican should take into account privileges to response to broader systemic shortcomings and theory. Competitive counterparts with the same H&R code, one net ground, tops unbound, and infinite amount of repairs to the patent law with no unified ground, only testing. IPR compensates structural advantages of case selection in the last page. 2 arbitrariness. There's no way to exclude this counterplan without also excluding uniqueness or agent counterplans that generate a DA. There's logic. If it competes as an opportunity cost, theory artificially excludes opportunity cost, that'll be more in condo. 4, no offense, rights, keys, warrant solves. T. Drop 1 at T whole resolution, protection of intellectual property rights, requires securing rights and trademarks, patents, and copyrights. That's a house. That's key to preventing an explosion of limits under their insurance because 2/8 will race to find tiny, squirrely apps that are minute changes from the status quo. They don't mean functionally. They affect only the area of the area of patents. They don't mean textually. They specify only patents in the plain text. Look, this argument is silly, but they dropped it. Don't let them come back from this. Reasonability from the other page doesn't solve. They didn't provide a counter interp, so their interp isn't even reasonable. Functional limits don't check because the apps might need distinction from this flow, and they don't have offense on this flow, so it's only a risk of our offense. Balls calculate. Concede the burn test competition, research, reject the argument of the team. Condo, we get what we did. 1, flexible accountabilities are key. Strengthen. IPR is nebulous, requiring multifaceted testing. Apps, sandbag, best offense, TVC. Personalized speeches, prep advantages, and vague claims. 2, logic. Condo is bad as an unpredictable, non-resolution rule that denies the negative status quo, which should always remain a logical option. Arbitrary rules are worse than no rules. Allowing the apps to unilaterally redraw the bounds of every debate, displacing substance, and reasonability applies here, but not to T, because their interp isn't reasonable on T, but our interp is reasonable here. Reject this defense. 1, diminishing utility, adding more advocacy, speaks and value into their strategic liabilities. 2, skew inevitable T, DA speed, highlighting firmer case. Reject dispo. 1, definitional consensus. There's not. 2, force parent process counterplans. Full piece place. 3, cancel flags. 2, EC dictates the blocks. And no add-ons. 1, Callaghan isn't a laundry list, which means it links back to the 2 EC warrant. 2, Miriam, no internal link to the aft. Aft can't deter current hippocyte bow that's progressing in the scope. And there's no reason why patents are key. It says regulatory mechanisms are key, which is accounted by cap cake. You see the firm test competition redirecting the argument, not the team where it was never floating pancakes. Fiated domestically. Core clog. 1, concede Capsol's client warrant from Zittelman means there's no impact to the trade trend. 2, counterplan also issues PTO guidance to trends practicing entities, so it solves. Billman is about cancellation towards cancellations towards counterplan also prevents that. The other cards are about why having patents are key to innovation, which towards counterplan solves speech and errors. Keeps the firm test competition research reject the argument, not the team. Calamity. Extension framings morally repugnant several impacts. 1 is genocide. It rationalizes suffering of minority groups as impacts 2, which don't even register because extinction categorically outweighs the framework. Vote neg if the reading of the 1AC causes more harm than good. Prefer 1, moral agency. Kahani 50, force to or context of which consideration conflict with moral use. Study tested in relation to a util and greater good force range employing outrage measures found in sentency rejoice sacrificing to save greater number as associated with the greater good util associated with psychopathy, egoism, lenient attitudes, transgressions that are opposed to impartial for the greater good. 2, critical thinking can reduce a 8-minute advocacy to a 4-second sentence, which trades you not to defend language sources justifying racist and sexist discourse and unpredictably muting most of the 1AC. The ballot must be a remedy for bad rhetoric. 3, logic. We have the agency to direct our subjectivities vis-a-vis extinction impacts, but not to enact the plan. They plus the case 4, gut check. If they do something actively harmful, then only this round framework goes away. Even if we don't win spill up, you should not reward scholarship that causes people to overlook. No violence. Fairness is wrong. The 1, the K outweighs by teaching students to be ethical. 2, turn focus on ethical frames and rejecting extinction impacts. Reverses top in unfairness by incentivizing teams to read controversial positions and real DAs with real impacts. 3, non-unique structural barriers of fairness like camp speed and no restrictional research. 5, double bind. The framework is a question of justice round. In our case, where fair security is extinction. K is a classic and well-researched generic. And 6, arbitrariness. If any violation is enough to vote on, the debate becomes a context of trying to catch the other team stealing the half a second of prep or going 1 second over the timer. No perfcon. They drop the 1NC preempt that it's to prove a serial policy failure. Perm do both links because they include extinction, the warrants, and extinction bad. Case bad is a claim without a warrant. It's not a floating pick. And the alternative is to vote negative to reject their unethical investments in this debate.
Okay, 6.
5:45. 5:45. Okay.
I got it. It's not like it downloaded.
Order from order.
Yeah.
Okay. 1, 2, T protection, necessity, and then G. Alright,
Can you repeat?
advantage 1, advantage 2, T protection, the necessity counterplan, the extinction. Very good. Alright, we're all good. Go. Okay.
Pandemics, constitution studies proves that mutations in bodies are quickly overwhelmed. That's see the plans also we solve the map event. The second event, military supply attacks away, flow force on my DOD, comms causing nuclear breakdown. SCD failure, kinetic attacks, and first right that goes nuclear, that's cured, they dropped it. So the case is true, and also this every argument on the KT production concede. The 2NC IP production rights is based on the exclusion, which is the card they read on permanent carbon for the necessity carbon. The plan is that because, which means that we don't, which means that they write our card interpretation for us because they've also defined protection on permanent carbon, and we meet that interpretation. We also get a new interpretation because the violation had changed. It was 1NC was only about the entire area. The 2NC also said all protection. Training production means expanding all coverage. Now I see the database of every core, MBA, and core, have a pattern coverage, work analysis, more core, strengthen IP production. What does it make it easier for strengthen IP or strengthen where means consider strengthen predictability there offer the resolution. Obviously it says and or, so you get to pick an area, otherwise they lose the infinite picks and it's arbitrary reasonability, anything else. Because the subject necessity kind of parent plan solves the terminal basically drop. There's no more for why. Hey, inventors don't apply, I'll get there later. And inventors is used to elaborate identification and detachment of new genes and to roll out vaccines. And it's synthetic biology to solve all disease. They dropped the add-on times bad, so we definitely solve this. Because synthetic biology, it also solves it's also at least terminal defense of the net method. The plan solves this PDD to have shine 24 loss. It's like species farmers keep on conservation global for slow made. Many plants are hanging on by their critical environment to the conservation effort, driver based include habitat loss and warming. Offer disease, driver medicine, and intervention solution that using to prevent disease, for example, drug development, is reversing. That's permitted both sweeps with any residual offense or a deficit outweighs the carbon uncertainty as a precedent that any company's patent rights could be taken away under any arbitrary circumstance when necessity is required, which is obviously not a term where they dropped the patent speed ups on a batch plans, and decreasing IP would obviously make future production look more hollow, but the carbon is also not permanent as per their estimation for the carbon, which is any patent reduction is fought and violates international treaties, carbon industries that were not relying on patent abolition, which has to get opposition from carbon companies to abolition, the governments to depart from the international treaties, including multilateral trade agreements, and those solves better or differences to the plan. None of the two evidences about the plan, and they've conceded the case solves sets at 100. The plan is flexible since it allows for changes in scope of direction based on the AI and scale of direction, which is how the licensing is also flexibility. Read the block, Russell, the truancy was new and it solves better cards, so we have to get new answers. They have no bad card about the plan, so you should hold them to that standard. The doc is not shoehorning, it is clear deal uncertainty. And independently, the necessity doctrine has never been used in the context of IPR, which is truancy context, which proves that it would be uncertain that any uncertainty outweighs or warranted. Rough estimate evidence says that when companies do not think that their rights are protected, they won't invest in AI in the first place, and would do trade secrets instead. Public enforcement fails, their evidence isn't. Let's do the fact that AI corporations have tons of money, and the public can obviously not sue against it, which is truancy evidence. And they had no card about the plan. Unfairness, whatever, standing fairness, punches the company from the Shelby and human market, which was an innovation lobby. And 20 new structural industry, they claim to like innovation creating discussion or responsible for significant advances or claims are asserted by companies as a vested interest in restricting the competitors' tech. And say no is also huge. Truancy warrant is the government recommends the same provisions. When you see Jordan's and actions of the PTO doctrine would reject the half in the status quo, absent fiating the absent happen, the government literally cannot happen no to answer zero solve C, the applicable solves because it fiats the PTO says yes, which the government doesn't, and if you think why the permits better perm to the counter plan, they wrote the text wrong. The counter plan is not actually competitive, it includes all the words in the plan, or they don't have an benefit based on the exclusion. Counter plan should be of text and functional when objectivity, there's no objective measure for function which expert political literacy causes such invention to background functionally, unless there have been normal means threatened and recommend choose like APES statements, right, and consult ICJ commissions, which is some equal to each remaining contract benefits with different price cost, but cycle then satisfying research, there's no ground to remain benefits solved. They also the self-custom that advice the block literature cross sheet drop functional limits like prices, core clocking case solve their opportunity answers, there's no firm giving our interpretation solve scramble for important technical legitimacy, so you can the words limitations are not ad hoc, it's normal firmly understood as scramble, no unbeatable firms you can't impact turn it is that 2 days, you can see carefully and it's so willful 2T add-ons are so blank, Jimmy loses, so salty, take us and pigs, every word. No impact fairness, I can say no Erickson, he's old and doesn't define a word of resolution, no arbitrariness, one link term function only is not objective and it's arbitrary as well. 2 norms all that's consistent use for decades and validate norms the existence of a planet proves it's critical. He gives us some way to determine what is in the planet. 3 is someone will prefer the best model of doing decisions for top guiding 1 conference the center utterly with plans not T2. T is function nobody thinks that these types always norm shape predictability 3 subsets 3 size factual top class must include the entire residence which violates syntax. For other issues to the comprehension to the planet cover over another issue subset that by computational legitimacy was above the 0 depths are certainty given set out ways. Flip the script, they contextualize none of the depth to the firm we made to be obviously getting answers into here. They just asserted a brand the firm planet does not none of the firms that planes 1. We have a firm that is over US production it could be taking away US military rights. It's obviously solved 2. We have a firm that knows for sure market copyright protection using for law less than 1 evidence and it's not about the patent of the patents after said any application of the rules goes over which is the 20 evidence is also recycled in the same IP key even if the text is like the function could be specific. Extension K. Framework only about the places that have terms of that places are really because it compared to all the links with the unique justifying versus unpredictable loss or evident critique that many word after an individual attached to one see it forces they have to be perfect one that has perfect themselves every speech who doesn't prove their value and prove that they cannot solve it's not a word but just to go for that they can't solve fairness that way it's the only fact that it solved by the ballot it's a logical person and they rely on it to which proves the competitions they gave way to there's no office one battlefield same selectivity all because like company rights religion always here's which I internalize all sense they don't believe in putting that goes well because it's goes to certain watches to feel good while nothing actually changes creating an alibi for restoring the outside space fairness is a wing because it suits all the links if we win it there's no critical thinking you can with the plans over success top so you can run adjudicating microaggressions back and force the team to go through more lines to take cases that way. Fairness as well being zero line and no structure very about it also and yes it's about just this round. And the only other thing was the economy of the place through the use of process having the knowledge of some kind of 18. Soccer with limit logic has limitations of no positive and effective altruism detail by a pressure question for everyone athletic and education humanity concerns the future generation positively associated and the last term is that permutations you both would perm to the all and fairness paradox would fairness paradox and truth testing would also obviously turn every argument man on the K because we cannot fairly answered it because it was not to the plan. And
5:45.
Yeah.
Sorry, what was the perm y'all extended? Not the perm you did.
Okay, so we had a perm that like applies the towards to like protection. So
Yeah.
then we explained as like military protection, like the military,
Protection from.
like about
said
the
other
military.
issue, yeah.
And then we had a perm that like decreases IPR for like trademarks and copyrights. Just how we explained it. So it's like not decrease patent.
Okay. The necessity counterclaim, the claim. Okay. Yeah. We're good.
The counterpoint solves and avoids a massive net benefit of a disease and establishes infringible IP standards in patent law by incorporating the necessity doctrine into AI inventorship. They've conceded that supposed for broader IP, which enshrines the doctrine of tortious necessity into the IPR. That's how it solves disease better than the plan. They drop that the counterpoint is key and turns case absent necessities. Companies will hoard life-saving tactic vaccines and medicines because they have a profit motive to do so. Because based on the patent's rights being exclusive, the counterpoint reverses that by making them infringible in times of public crisis. That answers the holds assault the net benefit. A framing issue for the whole solves things. There's any the counterpoint definitely solves the case if there's any risk that the counterpoint solves. Even if AI will provide the capabilities to solve pandemics, they won't be implemented because companies will hoard that tech. So the counterpoint, so the plan does not solve. So the case is essentially net benefit to the counterpoint also. But now they say Purdue both it fails. The job of the counterpoint bans the plan because it explicitly narrows jurisprudence to exclude the IP as a right, an intellectual property, and applying patents as a right for AI inventorship. That means, and there's no explanation why you just do the first part of the counterpoint. So you do not give them to a new the two error. They say we drop the patent. They drop patents are key. It does not matter because the counterpoint does include patents. The counterpoint just changes the standard for patents. One, but there's multiple answers to the top level certainty stuff. One is that they drop that the status quo is uncertain to the threshold. For the counterpoint is some departure from the status quo uncertainty. If the right that certainty is so important for investors, then the counterpoint should be sufficient signal to that investors. Two is that it's happened before. Investors are familiar with the system and makes them feel comfortable with that protection. That's hell. Fiat, they drop the fiat solved because it assures them the plan is key to investors. They just want some signal protection for the government. That's working. Three is that the plan is worse. The inflexibility of the IPR regime now makes the plan more uncertain in the counterpoint than the counterpoint because there are no allowances for important deficits. That's the whole evidence. They say the plan is flexible. No word in the 1 AR. The 1 AR is extremely blippy on most of these deficit claims. The plan is not flexible. The current IPR regime does not make any allowances for necessity or the public crisis. They say licensing solved. I'm not going to read the blog because again, the 1 AR is not a constructive. If you vote on this, they're going to be really upset because we read our solvency cards entering their solvency deficits, not for licensing. Regardless, the licensing won't be used because the companies have an incentive to hoard the tech. That's above. Now they say the app's not shoehorned in the existing regime. That's not true. The app is shoehorned because they don't make any amendments to the IPR regime. Now they say they want investment into IPR. That's wrong. The public, we've read evidence that the public does that companies want to hoard their information, which independently turns case. They say towards crash innovation. Wrong. We've read evidence specific to intellectual property rights and patents that say only making allowances for necessity is sufficient to solve. That's the whole evidence. Even if broader towards integration into IPR might make some decrease in innovation. It doesn't matter because ours is only in the instance of when the public necessity demands otherwise. Now they say PTO says no, this is wrong, and was answered by the 2NC. They recommend the exact same doctrine through the same thing. We're again our agent USOG, so we can figure out just they cross-apply fiat solves from the other deficit because it does because we are the USOG. Also, it integrates. It's not the SQO. It's the same doctrine basis that just changes that slightly. For the counterplan, no, it's in bio cross application. The counterplan it also implements a regulatory mechanism which our own impacts evidence test is sufficient to solve. The counterplan uses torts to regulate onslaught of symbio, just like the plan does. That was clearly in the 1 AR, dropped by the 1 AR. The 2 AR will say that certainty is key, but the 2AC evidence says only the regulatory mechanism and certainty in result is key. They also can't solve the internal because they are hard about big pharma making environmental changes to effort. So we've an external public trust in here. That means it won't get implemented because they gatekeep the solution. Only necessity doctrine solves because it forces companies to share that tech. It's also not our scenario because our scenario is about pollution to countries in the status quo. Theirs is about animal endangerment. strike off gobble. It's about patent abolition broadly, not the counterplan. So no patents, keywords, because we are patents now. The counterplan over other issues fails. They 1 AR drop too many deficits to make makes this viable 2 AR. At the top, the counterplan bans the plan, and so does the perm. Any perm that narrows jurisprudence to exclude rights and excluded demanded, and the plan that excludes the counterplan also drop. There's only a risk of our offense because increasing tortious over having no basis for tortious liability means that investors get confused. And there's no, it doesn't spill over because it requires lucrative alternatives require an exact mechanism to transform the patent system. So they also drop that the firm also lacks a discrete application. The Cornet evidence it's really good and said the death knell of action is just general recognition of causes and general recognition of things like protection. But the counterplan also does not. The perm is also bad because it adds function. One is plan sophistry, textual competition, rewards obtuse plan writing, words like funding not and solves PTA trade-off politics, and econ kills fairness. Fake plans independently cause shiftiness, killing clash, and education and church offense to is arbitrariness. They've conceded the Erickson evidence that says that the plan debate should only be involved mandates. So it's most predictable, not resolutional. Their intertextual combination is arbitrary and self-serving. And just this and bracketing out arbitrarily our counterplan, which is bad. They dropped that removing mandates of the plan solve the permanent counterplan checks. All their cheating counterplans that they list in the 1 AR objectivity is wrong. They link because they include functional competition, which includes the unobjective violations. That's offense because vagueness or dictionary and language terms make the text and meaning ambiguous. Function is objective because it's backed by evidence it needs to adjudicate. Again, all the counterplans that are cheating are checked by permanent counterplan. Ours is only rights counterplans. The 1 AR doesn't list any offense here. So,
Are you running to the restroom really badly right now? It's okay. Sure, we got it.
Uh, 238.
put everything on the counterplan, I guess. Perm do the counterplan. Despite have been Blippi, but Jordan is usually unclear, which is why he didn't get a speaker award, but it was certainly said in the 1AR and dropped in the 2NR. This might have been the hardest battle you had to write all weekend, but as long as you conclude it's on your flow, then it's TKO, since there's no severance or impact to severance. Though 2NR only says perm do the counterplan, checks bad counterplans, but drop that we made the argument against this counterplan now. Pandemics cause extinction. Globalization has made it so disease spread rapidly and collapse civilization. Examples like COVID, SARS point to the next disease being the brain. The app solves this because it changes current PTO doctrine that strikes us down, so the app can allow companies to use AI to create vaccines that can solve for extinction. This means that the deficit definitely implies it's huge. The PTA will say no. The 2NC and 2NR responses were very clear. Russell said that, quote, the counterplan recommends the same provisions of the app. This is unresponsive to our say no warrant. The current PTO doctrine says that it is illegal to allow for AI inventorship, so absent fiating the planet, fiating that the PTO adopts inventorship, the PTA will always say no. That's what AC, Yaku, and Horde. They don't have any evidence that the PTO wants to change their doctrine, which should frame this deficit. The CEO's the counterplan without even getting into the competition debate because they cannot solve the app, and conceded disease impacts mean that you must vote affirmative to reduce the risk of any existential disease. Their only coherent answer is trying to cross-apply the solve the 2NR, but strike that off your flow. Rice will impact it out why we don't get to cross-apply our sin vial add-on, which should also be applied to this. No justification for why the 2NR gets new cross-apps to reject it. There's a couple of reasons. One, it's a slippery slope that allows infinite new combinations of counterplans extended to the block and decreases effective strategic vision. Decking education. Two, you must stick them to it. The 2NC must stick them to only the 2NC arguments because 1AR strategy is predicated off of that. Independently, Saul's better is wrong. None of the 2NC evidence is about the plan, and they conceded the case solved. 2NC cross-sexes said that it's just about patent bad, which is an impossible neg valve because they dropped way too many arguments that they're good. That was the disease stuff above. Now, Turn's case is also so wrong. The only impact is hoarding, which doesn't matter and doesn't have an impact. 1NC evidence says that as long as pharmaceutical development and innovation occurs, solvency is sufficient. 2NR drops that, so the threshold should be very low. The 2NR also does not have a terminal impact. That's why hoarding technology is independently bad, while the 1AC evidence sufficiently says that even if tech is hoarded, if there's sufficient innovation, then that's enough to solve extinction. So no Turn's case. Now, perm do the plan and the counter plan over protections broadly.
Over a distinct issue.
Oh, that's broad, really?
No.
Perm do the plan and the counter plan over a distinct issue. It does the plan while applying necessity to compile, decreasing copyright trademark protection, just not patent, so it doesn't include the plan. Do both answers don't apply. This was flagged in the 1AR. The counter plan is under a different issue, and legal regime deficits are zero. It solves the internal, since the net benefit is not germane to the plan. They have no reason why doing the plan is key, and the perm does the counter plan over a completely distinct issue, which is sufficient. No deficits, yes. Net benefits. The perm doing the counter plan over another issue avoids the say no issues that come with applying necessity over the plan. So we have a massive offensive reason why doing the plan is good. Now, counterplans must compete on both text and function. Prefer one after-on functions. Only is terrible for after-on function. Only destroys the app because they allow counterplans like offsets, recommend non-binding consultations, inter-branch conflict, and any threatening counterplan to compete. These were examples in the 1AR dropped by the 2NR. This nukes the affirmative because there's no deficit as to why establishing why a commission to recommend and plan the state, the ICJ, the WTO, or any permutation of 100 of these actors should be used. That weighs that ground frame through internal links. Offense, defense means our competition model is better. The 2NR drops after onto, so and concedes the topic is neg bias from tons of functional limits in case and core clogs, so any defense to any other shit is sufficient. Now, scramble firms is wrong. Drop forces smart text writing. 2A's never want to make their counterplan text super long either. We exclude that also since we reject scramble firms. That's in the 1AR. Also drop our model allows only definite deletion of words with zeros of word scramble and transplant vagueness. They say arbitrariness. That's wrong. Text is a reasonable way to determine competition used for a long time and is commonly understood. So it's a community norm. There's a reason why people have fake deficits ready to go against firm other issues. There's also a reason why the 2NR had blocked for this in the first place. Text means that there is some accessible way to determine what the plan actually does and whether it's exclusive opposite from the counterplan. Accepting arbitrariness is also fine. You should endorse the best model, i.e. Wolfie's counterplan is bad, we should accept the theory, even if it's arbitrary. Erickson is also irrelevant since the terminal to this is predictability, but they should sacrifice some predictability for a more fair debate, also not going for objectivity, so there's no offense there. Now, Neg Brown is a non-starter for any issue. Evaluated through internal links that was done above. Under our model, negatives still get process counterplans like Quartz Concon, or any counterplan that has an external net benefit that's germane to the plan, which means that it solves all the Neg Brown offense. There's no reason why threat or consult, ICJ, etc. are key to upholding the entire Neg Brown. Look, any risk of this term solves means that the plan solves the internal and avoids the huge deficit. But even if we lose the competition debate, say no is sufficient.
And they say the plan is too big.
They say
the term is too big.
They say the term is too big.
But then they conceded that the implementation of the term could be
They
specific.
conceded that the implementation of the term is what?
Specific even if the text
Is specific even if the text is vague.
is vague.
Debate.